What is the difference between negligence versus malpractice? Negligence and malpractice are legal concepts often used in personal injury and medical law. Although they both involve a failure to meet standards of care, they are not the same. Understanding these differences is essential if you've suffered harm due to someone else's actions. Negligence refers to a broader failure to act with reasonable care, while malpractice specifically involves professionals like doctors breaching their duty of care in their particular field. Legal distinctions between negligence and malpractice. Both negligence and malpractice fall under civil law, meaning the injured party can pursue compensation through a lawsuit. However, Pennsylvania law differentiates these claims based on how and where the failure to meet standards of care occurred. In negligence cases, the plaintiff must prove 4 key elements. Duty of care. The defendant owed the plaintiff a legal duty to act reasonably. Breach of duty. The defendant's actions or lack of action fell below that standard. Causation. The breach directly caused the plaintiff's injury. Damages. The plaintiff suffered measurable harm. Malpractice, on the other hand, is a type of negligence committed by a professional in a particular context, like healthcare. Pennsylvania law requires an extra step for filing malpractice claims, a certificate of merit, to ensure the case is reviewed by a qualified medical professional before going to court. Difference between negligence versus malpractice. In medical settings, negligence in healthcare might involve simple mistakes, like administering the wrong medication dosage. These errors are typically unintentional but can have severe consequences. Medical malpractice goes beyond ordinary negligence. It happens when a healthcare provider fails to follow the accepted standard of care, causing harm to a patient. Examples of malpractice include performing surgery on the wrong site, misdiagnosing a condition, failing to obtain a patient's informed consent before a procedure. Unlike general negligence, malpractice requires a professional relationship between the patient and provider. It also involves a more technical assessment of what a competent professional in the same field would have done under similar circumstances. How does Pennsylvania law address negligence and malpractice claims? Pennsylvania law sets strict procedural requirements for filing malpractice claims. The statute of limitations is generally 2 years from the time the injury was discovered. In some cases, the discovery rule allows plaintiffs additional time if the harm wasn't immediately apparent. Additionally, plaintiffs must file a certificate of merit within 60 days of the complaint. This document confirms that a medical professional has reviewed the case and found a reasonable basis for the claim. Failure to meet these requirements can result in case dismissal. If you or someone you know has suffered due to negligence or malpractice, the law offers ways to pursue justice and compensation. Legal claims can hold individuals or healthcare providers accountable, influencing better practices and reducing future risks. To take action, reach out to Luxenberg Garbett Kelly and George, PC at 724-658-8535 or visit us at 315 North Mercer Street, Newcastle, Pennsylvania, 16101, United States. Our attorneys are committed to helping you navigate your case and secure the compensation you deserve.